Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Welcome back to Just Verdicts. I'm your host, Brendan Lupetin, and I'm super psyched to have just a nationally recognized, crazy, almost to the point where I'm like, how did I get this far along in my podcast where I get to interview people like this? But today, I get the great pleasure and honor to speak with Harry Plotkin. Harry, how you doing, man?
I'm doing great. Happy to be on here. I'm just equally honored to be on here.
No, I really am psyched. And, I was saying to you that, and I don't think I would get a lot of pushback from a lot of my friends and fellow trial lawyers out here that, the western side of our state in Pennsylvania, whether it's fashion, whether it's, just cutting edge anything, or whether it's trial practice and strategy, we're always like 5 to 7 years behind the times. And I say that because, for anybody listening who doesn't know who Harry Plotkin is, you're basically living under a rock for a long time because, any conference you go to TLU, any of the other big conferences, trial guides. Harry is the man. He's consulting on, just some of the highest level cases around the country. And that's why I'm so psyched to have you here today. And so with that big wind up, Harry, can you, just tell us a little bit about yourself, your practice? I know that your wife also is a trial consultant with you. So I'd love to hear just kind of background briefly how you got into this. And then how did you get to the point today, where you're consulting on, these massive, cases all around the country?
Sure. Happy to. And let me just say, even though I do feel like jury selection wise, I'm always 5 years ahead of the curve, and I'm doing things that usually others aren't doing in every other aspect, fashion, everything else. I'm probably 5 years behind Pittsburgh, so I'm not embarrassed to say that. But yeah, so I've been a jury consultant now for a little more than 20 years actually. So it's surprising how fast it's gone. And so my background is in psychology. I got into this. I had a psychology background, and I probably out of school thought I would be getting into marketing or something like advertising or who knows what. But I just fell into it. I was working with some experts and some of the lawyers found out that I had a background in psychology, and they were asking me to, how do we explain this complex stuff to juries? And then just, fate came in, and I had a buddy that I went to school with that was starting a jury consulting company with a couple of jury consultants and asked me to join him. And so, kind of the rest was history. So, when I started doing this, when I spun off my own practice in like 2006, and I would just take whatever came in the door, man. I did criminal trials. I did, any state in the country. I did plaintiff defense. I did, I would do patent cases or any kind of cases and everything. And then kind of slowly over time, I just started cutting things out. It's kind of funny. Like I think the first to go was criminal. I'm like, this is just too much for me. It's really not my wheelhouse. And then, at some point I cut out, probably 10 years ago at least, I cut out doing defense work entirely. I'm like, what am I doing? It's funny it took me so long to figure out that like my heart is not in this. I think my heart was out of it for probably at least 4 years before I realized that like I'm really not, I don't believe in this stuff. Like I'm kind of not wanting to win these cases that I would work on the defense side. So, I only do plaintiff stuff. And then, it just kind of went from there. So, and I don't really do commercial cases anymore. I don't really like business against business cases very much. They just don't interest me that much. So, so I do love doing, victim related cases and getting justice for little guy. Employment cases, PI cases, product cases. I really don't do a ton of like class action, mass tort type things. I just really I like seeing, a plaintiff, get their life improved and a company have to get punished for these things. I picked a jury about 6 months ago, and the lawyers were just sending me pictures about this plaintiff. She was living in this like total slum. That's all she could afford. And she slips on the stairs because the landlord wouldn't fix this roof that had been leaking for years and hurts her back and everything, and got her a great verdict. And now she had a housewarming party at this beautiful house. And that kind of stuff just warms my heart. And you don't get that on I don't know what on the defense side, what if there was some defense consultant telling you about how happy they were for some insurance company, but I'm not feeling it. So anyway, but so yeah, my wife Claire also does the same thing now. She kind of learned from me, and now she's probably doing even better work than me. So at least there's two of us out there hoping to help as many plaintiffs as we can.
As we talked about ahead of time, again, if we have time, what I want to cover with you today are, from your vantage point, some of the biggest mistakes, when you are getting brought into a case that you're seeing the plaintiff trial lawyers make, whether it's in, how they work the case up, how they're looking at how to present the case, and then anything you've seen, whether it's in jury selection or the actual trial, that whether you're seeing them over and over again or just kind of like big picture red flag issues we need to avoid. Love to hear about that. Then want to talk about, if possible, in Pennsylvania, we can't suggest or ask for a specific number for pain and suffering and non-economic damages. So I'd love to hear your thoughts on that. And then I'd like to end with some jury selection concepts and tips that you can share with us. But before we get into all of that, I would briefly love to hear very quickly. I was looking again at your list of the cases that you've consulted on over the years. And I mean, the verdicts are unbelievable and in such a variety, even though they're predominantly, mostly individual personal injury cases, just a lot of different types of amazing verdicts and, employment cases, medical malpractice, general personal injury, slip and fall case and so forth. But I noticed because, this was the scuttlebutt over the last few weeks that you assisted Rowley and Company with that massive verdict in that Sanchez case out in, was it New Mexico?
Albuquerque, New Mexico, yeah.
I mean, to the extent that you can, share with us anything about that, can you kind of walk me through, how you consulted on that case and what you helped, that team and obviously, super famous and amazing attorney, Nick Rowley, what role did you play in lead up to that case, or were you, there during the case?
Sure. Yeah. No, I was there for jury selection. And so basically, a lot of cases with Nick, I'll get a call or a text like a couple weeks before trial saying, hey, you want to come out to Albuquerque and pick a jury with me again? And we've been doing a lot this year. I think we picked 5 together this year. And, as long as I'm available, I'm like, yeah, absolutely. I'll be there. So yeah, just learned about the case, talked a lot with, Keith Bruno, who tried that case with Nick, and Keith did the opening statement and a ton of the really good cross in that case, and Nick did the voir dire and closed in that case. Talked with the local counsel about some of the issues of the case. There were a lot of bad facts in that case. It was I kind of have to sometimes I have to play devil's advocate for the attorneys I work with, and sometimes when the lawyers are going in, they're going, man, this is this is a slam dunk. There's nothing we need to worry about. Luckily, in this case, Keith is kind of feels the same way. He was like, I don't know about this case, And when he does that, then I'm kind of doing the other. I'm kind of telling him all the good stuff about this case and telling Nick about the bad stuff about this case. So I got to get up to speed on the issues and helped give some topics for Nick and voir dire and Nick, and Nick would do a great job awesome job on his own, even without me. But I gave him some good topics to talk about in voir dire, and I was there in the courtroom and helped decide who to get rid of and push them for cause, we need to get 2 more people for cause. Based on the number of strikes there, hey, if we get 2 more for cause, we're golden. And, he did an amazing job getting a lot of cause in that case. And so, yeah, and helping pick the jury and every state you go to has different rules about voir dire and jury selection. So I got to kind of get up to speed on that kind of stuff. And in Albuquerque, in New Mexico, you kind of go one by one. You go, you have a certain number of strikes, but they go, okay, juror number 1, plaintiff, are you striking or are you keeping them? And you got to go through. So you got to figure out, okay, who are the ones you can't bluff. You blow all your strikes early and then you don't have them saved up for the people you need. So,
right.
Yeah. So once we picked the jury, they were off and running. I always give advice to them and to all the attorneys I work with on opening and themes and how to deal with tough issues. And they were off and running. And I'm always in touch with people during trial for advice for closings and things like that. But I'm not usually there during that phase of the trial, but I'm in touch with them. But that had some bad facts, but some great facts. And I remember one thing that really struck was one of the one of the jurors, I mean, one of the worst facts about that case was our plaintiff he was in his late 60s. He had a lot of health issues. He didn't have his wife. He was a widow. His wife had passed away, maybe 5 years before. Didn't have a girlfriend. Came into this clinic basically just looking for testosterone treatments. He was just feeling he had no energy and everything. And they just pushed all this stuff on him, ED stuff on him, these weird injections on him. He took it though. I mean, he accepted them. So he obviously had an issue. But I just remember when one juror got up there and was going like, this case is ridiculous. Why are we here? And she said something like in front of all the other jurors, like, why, this is such a ridiculous case. Like, this guy's 66 and why wasn't he just basically like retired? Like, why does he even need to have sex anymore? And like, you heard an audible gasp from a lot of the other jurors. And I was like, making note of who was really pissed off on the case. And that's when Keith kind of was like, okay, I think we can win this case now. He was surprised. He was worried that a lot of jurors were going to be like, yeah, who cares about, the sexual function of this guy who doesn't even have a girlfriend or a wife and he's in his 60s and he's got other health issues. Who cares? And the jurors do care. And that's one thing that I think, my job for over the years is to try to think like a cynical juror and tell you, like, never underestimate how cynical some people can be. But a lot of jurors are just not cynical. And so you got to believe in your case, and there are always jurors who are not cynical. You just got to get rid of the cynical ones in jury selection. There's always enough good ones that care about the things that are important to your plaintiff. So that was one of the big lessons from that trial. But I love that jury. I mean, it was a unanimous jury, and
Was it a state-based claim and not federal?
It was, yeah. So that was we had medical malpractice claims, but we also had some fraud claims as well, and punitive damages in that case. So and that was really about. I mean, there was some med mal to it also. There was some just terrible care where like the PA was delivering the care, a physician's assistant, and the doctor wasn't nowhere on premises and everything like that. So there was some med mal, and so there were some defense experts saying, well, that's totally normal standard of care and everything like that. But at the same time, they really tricked this guy into thinking that this is what he needed. They knew how to take care of him, and they really didn't. They totally dropped the ball. But our guy, and one of their other defense was in this case was that, hey, all of these things that happened to you were risks that were disclosed to you on all of the medical release forms that you signed. And I remember the morning we're picking the jury, I was like, yeah, but most people just don't, are unsophisticated. And that's when I found out they're like, yeah, but our plaintiff is a lawyer. He's actually a,
oh, jeez.
He actually does like wills and trusts and everything like that. I'm like, that excuse probably won't fly, but so, but the big theme in this case is that they take advantage. 100% of the people who come into this clinic are depressed, and they're just like, they're just fishing for these people who are just desperate for solutions to their life, and they'll sign anything. I mean, they're not looking for, all they needed to hear is a PA telling them like, this is gonna fix you, and they don't care about what they're signing. And so we made sure to voir dire on that. We definitely struck a couple of jurors who were like, I read and sign everything. You got to sign everything, and if you sign something that has a risk, that you shouldn't be suing over it. But everybody else was like, I remember there was one guy that we kept, an older, retired guy who was just like, I think the disclosures are like lawyers. They're just for the lawyers. They're not for patients or anything like that. The other side didn't strike that guy. So just knowing what the issues are, for the jurors is super important, and focusing on in voir dire on those things.
So I think that's a really good kind of pivot point to, one of the first topic areas I want to talk with you is, from your vantage point, mistakes, or whether it's misconceptions or things that you're seeing that lawyers, that come up often for you. And one of them to me would seem, just what you said, whether it's, a misperception or a blinding, or, not wanting to face the problems, or sometimes I think some people get overly preoccupied with the quote problems of the case, and then that scares them or causes them to overtry the defense aspect of the case. So whether you want to touch on that or just some general concepts, what are issues that you're dealing with lawyers on a regular basis to help them to improve their presentations and jury selection and their trials?
Sure. I do so many trials and work with so many lawyers that there is a long list of mistakes that I see made. It's not like every lawyer does like 20 things wrong, but there's some things that I see just over and over again. Probably the biggest one is I hear some lawyers tell me, I just have this rule. I never keep X on a jury. I never keep young women on a jury. I never keep nurses on a jury or engineers on a jury, or I would never keep this or that. Just never. And that to me is like a huge mistake, because your peremptory strikes are precious. You need to make sure that whoever you're striking is really a bad juror. You can't waste a strike or two on somebody who actually might be really good for you. I mean, that's just terrible. And so, and if you look at some of the biggest juries that I picked, a lot of lawyers are surprised. Sometimes I show them in presentations and I go, these are the occupations of the people who were part of this $400-something million jury, or this $150 million wrongful death jury. And they're shocked. There's a software engineer on there, and there's a nurse. I mean, I had I picked one with a friend of mine, just a shoulder surgery case where we got, in Orange County, which is really conservative here in California, and we got $multi-million dollars, and we had our fourth person was an RN, and we had a doctor on the jury. And so, I just tell people, one of the biggest mistakes is just judging a book by its cover and prejudging jurors and having that hard and fast rule, like I never keep. I mean, so, and for me, it's like, if you have the luxury and voir dire of learning a little bit about their values are much more important than what their jobs are. There are great engineers or great doctors or nurses, any job. And they're also horrible. I've seen horrendous social workers and teachers sometimes, not all of them, but a lot of them are great, but I've seen horrible ones before. I've seen horrible, sometimes in California, a lot of the plaintiff bar is like, oh, all the African-American jurors and Hispanic jurors are going to be good for you. And that's not true.
Right.
So never judge, really. And one of the things I always teach is like, listen to them. And if I don't want to go back there when we're during a break and talk about who we're striking, and you're going, I think we have to strike this one juror because, he's an accountant, and I'm worried that he's not going to want to give, this money for something, like non-economics without a formula. And so my thing is like, then ask him that question, and if we're done with voir dire, then why didn't you ask him that question? Now I know in Pittsburgh and Western PA, it's a little tougher, you're limited. And so when I'm in federal court, sometimes I do have to make these assumptions, and it's okay to do that. If that's all you have as an occupation and you don't really know that much about them, that's okay to stereotype. But if you have the luxury to even know a little bit about how they feel about the liability issues in your case, I would always choose what they say, as long as you believe it, what they say, and they say it really, definitively, over what their jobs are. And so I never pick a jury based on gender, age, ethnicity, even jobs or things like that, unless I have to guess.
Case in point, my Maggie from my office and I tried a case last year and got a good verdict on a slip and fall. And I remember that was up in Erie, and that was like the classic Wild West jury selection, which I love. Open room, judges isn't even in there, get to talk to everybody. But one mistake I made in that I hadn't really done that too frequently was having Maggie and I both kind of like really identifying who were going to be the people most likely in the ultimate panel to select from and so forth. And anyway, fast forward, the jury comes in, that feeling of like you finally, they sit them, and there's always that, it was like, oh, I don't remember picking this person. And I remember there was this young Asian guy that wound up on the jury. And I'm like, Maggie, who is that? I do not even remember. Like, I don't think we even talked to him somehow. Like, I guess he was just quiet during the discussion. And then like we're reading through it, and he's an engineering student. And I'm like, a young male engineering student. Yeah. I'm like, what in, anyway, fast forward, we get a good verdict, and he makes a beeline to come and talk with us afterwards. And he's like, did you feel that verdict was fair? And I'm like, well, you guys entered it. I mean, it was great. I mean, it was way, way more than what was being offered. So I accept, what the jury says. He's like, well, I thought it was crazy back there. He's like, nobody was talking about his pain and suffering. He's like, I was fighting to, he wanted to award.
He wanted to get more, right?
Way more. And he couldn't believe what people were discussing about the numbers. And that blew my mind. What I would like to know though, when you say understanding the values or trying to identify some of the key values. So I do predominantly medical negligence cases. So can you give me a sense in that realm? And I know
Right.
it's a very broad stroke here, but what are the values that you're trying to understand about the specific jurors have to help you decide whether they would be a good fit or not for your case?
Right. So what I mean is, do they? You want to ask some questions to try to figure out how they feel about what there's on one hand like the criticisms that you're going to have of the defendant, and you're like, it's wrong. This is what they did. It's wrong to do this. It's wrong to do that. And the defense is going to have a bunch of excuses. Oh, it's okay to do. Medical now. Standard of care says it's totally fine to do these things, and you're saying that's totally careless to do these things. How are you doing? And so you want to get at how they feel about. I mean, you can't ask directly on that, but just the general concepts of what are your feelings about whether if a doctor is available, an experienced doctor is available, whether it's okay for that, whether they should be doing all the steps of an important surgery, or is it okay for them to teach and give a teaching opportunity to somebody who's less experienced, and maybe that's what the defense is saying. And so I want jurors who are going to be like, if it's a surgery and if it's a really important, dangerous surgery, like the most experienced doctor should be doing it, like period. And you don't want people who are like, no, it's totally common. It's not a big deal. And you shouldn't expect the best doctor to, whoever is qualified is okay. It's okay for them to do it. If the doctor's in the room, it's fine or whatever. So, because one thing that I found, and I do a lot of, focus groups and big data surveys. And sometimes we don't do it too much, but sometimes we'll bring back the same jurors. We'll see the same mock jurors that we've seen in another case. And when I've taken a look at them, what I find is really interesting, which is you can get somebody who was just horrendous in one case. Like you had a really good PI case and someone just defensed you in that case. And then you go back and you're like, look, in this other employment case, they wanted to give a ton of money, which tells me there's no such thing as a good or bad juror generally. There's no such thing as a person. You show me a juror and I can show you a case that they would be horrible for you on and another one that they would be great for you on. And it just depends on what their case-specific feelings are, because everybody has something that strikes a nerve with them, and everyone has their own sense of right and wrong. And somebody who may be like, oh, who cares about, hey, who cares about companies getting sued? It's okay for them just to care more about money than anything else, might feel totally differently about doctors. And, so really understanding not just, that's why one mistake that I always teach is like, I hate those questions about like tort reform questions, like who thinks there's too many lawsuits, who thinks there's verdicts are too big. That doesn't tell me anything. I can't tell you how many jurors who've said those things I've kept in the right case because they said some good things about liability that were totally willing to give a huge verdict. When they go in there, they're like, what are they basing it on? They're not basing it on really anything. And all they're really thinking in their heads are like, yeah, if I see like a stupid, frivolous case, like I'm going to get upset. Like, yeah, but who wouldn't though, And then those jurors I find though are like, when you have a good case, they're like shocked. They're like, oh my God, this is a totally legit case. And so I never put any stock in those questions. I never asked those general questions. And, because those bad jurors, if there's somebody who just hates all lawsuits, they're going to tell you with your other questions. They're going to tell you when you get specific about the issues of the case. But in med mal cases though, I got to tell you one thing that I look for in a good med mal juror is I want somebody who is really has a big ego. I want somebody who thinks so you want me on it. Like I'm your perfect med mal juror on the plaintiff side. You want somebody who's like, well, let me tell you something. I'm smarter than a doctor. I don't think they're any smarter than me. I could easily overrule their second guess things that they do. I worry about jurors who, and I always ask this question in med mal cases. I always go, you're going to be asked. I mean, there are going to be two experts in this case who are like medical experts. And none of you guys are obviously in the medical field. And I worry that some people are going to say, how can I overrule? You're going to have to overrule one of them. And one of them's going to say, this is okay. One of them's going to say, it's not okay. And you're sitting there and I worry, is anybody going to say, who am I to overrule these people? But who here could, feels, trusts your common sense and your judgment enough to overrule what a doctor is telling you, an expert doctor is telling you. I want jurors who are like, yeah, I could do it, because the jurors I worry more about the jurors who are like, how could I possibly overrule?
Yeah,
who
am
those
I
are the
to
ones
say?
who you lose on standard of care. They're like, I don't know I guess that's what the standard of care is. So I like business people in med mal cases. I like people who are like higher level jobs who like make decisions and And those people tend to also, in med mal cases, have higher expectations about the standard of care. I want jurors who are like, I'm not waiting, 2 months to get a procedure. Like I'm getting it now. And like, I'm not okay if a doctor says no to an MRI. I remember keeping a juror years ago in a med mal case, a really tough med mal case. And if you would have seen this juror, like she was like this wealthy looking corporate executive, and she had like a super fancy, probably brand name purse and everything. And I just remember her saying, we asked, anyone ever had an MRI? And she had one for like something super minor. And the issue in our case was that our girl did not get, they refused to give her an MRI for several months. And ultimately they find cancer, and they got to literally amputate her whole leg and part of her hip and everything. And I'm like, that woman is going to be like, are you freaking kidding me? Like if I ask for MRI, I'm getting an MRI now, which is how she felt in the case. So just the values of your case. And she might've been terrible at she might've been terrible in an employment case. She probably would have been, but that doesn't mean that she's a bad juror in your case. So you got to focus on the real issues where the rubber meets the road between what you and the defense are saying as best you can.
When you're picking the jury and, you're identifying values, and, let's stick with what you just talked about, how somebody who has the level of ego where they could, I feel like I can decide once I hear the evidence, I can decide which is the standard of care. It doesn't scare me that two doctors are saying it, and who am I? When you identify, say, a couple of those type of jurors, I imagine you don't want your whole panel to be a bunch of big egos. I mean, do you look for then, wallflowers or followers and people that they'll kind of just go with the flow? And, once you've identified the people that are most likely going to drive that discussion in the deliberations, or are you more, I mean, obviously it's like whatever you're given on that random panel, but do you look for that kind of makeup so it's not too many egos back there? Or not necessarily?
Yeah, that's a good question. I don't mind followers. I mean, if it comes down to, we got one more strike and it's between somebody who is going to be a really strong juror that someone others are going to listen to, not just a loud juror, but someone who's like got some authority and seems like a very fair person, and they know what they're talking about. And I don't have a sense necessarily that they're for us. Versus, and if I like the other jurors, and I think we have a couple of good leaders on there, and then you got this person who could be great for us, or they could throw a wrench in our plans, versus somebody who said some kind of bad things, but they're a total follower. They're like there's somebody who works at, in McDonald's, and they're in their 20s, and they're not that loud, and they, and even if they're like, I don't really like lawsuits, I don't really know if people should get a lot of money, I kind of disagree with it. I'm always going to strike the leader and not worry about the follower. I rarely will waste strikes on someone who I think is going to be a follower, or quiet, or even somebody who and usually it's like younger jurors, or sometimes, I mean, honestly, sometimes, I don't know if this is PC or not, but sometimes jurors who have a big language barrier, the other jurors are like, they're not going to listen to that person.
Yeah.
And they may not even speak up that much. Or somebody who's like a total, if you don't have to be unanimous, and I don't know, in Western PA, does it have to be unanimous on the jury?
No. In federal court it does, but in state court it's like 10 out of 12.
Yeah, because some places you do, some like Albuquerque, it had to be unanimous. Some places it's got to be, you got 8 jurors or something, they got to be unanimous. But if you don't have to be, I don't mind keeping somebody who is like not a leader in the sense, and maybe loud and obnoxious, but someone like that person's just going to polarize everybody else. They're not going to listen to that guy. If there's somebody who's just not, the other jurors you can tell are just already getting annoyed by that person. I would rather just keep that person and get rid of someone who could be a dangerous leader that others will listen to. So definitely knowing your leaders and your followers and who seems to have, I think I have a pretty good sense of who other jurors will have credibility with the other jurors. That's a real important point in who you're picking or not. So if you have a leader, you better be pretty sure they're leaning your way. You don't have to be 100% sure, but it's like you're playing blackjack and you get an 11, I might lose this one, but you should double down on it. Like I'm okay with doubling down on jurors that are leaning your way, but a strong juror who you just really don't know.
Yeah, that's scary.
Then I usually will, if you can, get rid of them. Yeah.
Okay. I want to roll in to get your thoughts on opening, and I do want to say, and I want to give you a hard time again, that
Sure.
I'm very disappointed that you stopped publishing your jury tips.
Yes.
because
Yeah.
for anybody listening, you've got to go to Harry's website, yournextjury.com, and he has this trove of just awesome articles that he wrote over the years, covering voir dire, covering trial, covering a lot of opening. A lot of the articles have a lot of great stuff about opening. And then you stopped, and I was like, "Why?" I got to the end of it, and I was like, "Wait, this last article was written like 8 years ago, or something, or 7 years, whenever it was," and I so disappointed. But that said, I'm not going to twist your arm to do it again. But can we roll into opening? What I'm curious about is, I still, I'm incorporating lots of different things that I hear from different great trial lawyers out there into my openings. And if it resonates with me, if it feels like comfortable with, like, I like that works for me. But I still largely follow, if you want to call it the ball or, reptile Keenan kind of format, some, pretty early on, some type of rule or rules that kind of frame what the case is about. And then we roll into the story, and then who we're suing and why, and causation, the damages, and so forth. What are your thoughts on just opening in general? Because I know that's an area that people, really consult with you a lot on, is help with their openings and so forth. So, are there heuristics or thoughts, and or new aspects of how you approach opening? Anything you can share, I'd love to hear.
Sure. Yeah. Just opening structure. I think to me, the structure of your opening is really, really important, and knowing what comes first and everything. I like openings that kind of do get right into it and don't kind of give a little bit of a summary at the beginning, or let me tell, too many, like, good mornings, and let me reintroduce everyone on the team, or who we're suing, or what the claims are. And I don't like any opening that starts with "this case is about." I really don't like. Not that jurors are necessarily going to dislike it, but I think you just get right into it. And so I think structure wise, usually the most important thing is to say, as we're here because, we're here because, a customer, slipped on a floor at Walmart and injured their back. And now let's talk about how this happened, or, we're here because somebody, whatever it is. But I think the first thing that you always want to start for in the structure that I like is talking about, if you're suing a company, or if you're suing a hospital or a doctor or something, talk about what the doctor, if there's something you have to educate them in. I like to say, now doctors know, and this doctor knew, or, this is what they know. And you talk about those things. So rather than saying, here, I need to teach you about the medicine in this case, and then the jurors are going, why are you teaching me about the medicine? I think it's much more powerful to say, one thing the doctors know when they're, trying to decide whether a patient is, it's safe to do a surgery is right for a patient, and this particular patient and everything, is they know this and they know that, and they know they need to know this and they need to know that. So you're educating the jurors on those things, but you're loading up like this is what the defense know, and they know these things. And then you come to a situation where you tell, or they know it's not safe to do this operation on somebody who's had this condition in the last 2 months or whatever it is. So they're and then you get to the point where, and you're leaving your plaintiff out of it. I think the best openings, you don't talk about your plaintiff until much later. So they're not focused on your plaintiff and what they did, or do they have fault in this case. You want to get them to a place where they're like, this defendant knew better. And then the next thing you do after that is you talk about what they did. They could have. So in this situation, in this hospital, they know all these things, and they know what they could have done for patients is to do this, this, and this. But instead, this is what they do. Now the jurors are going, oh my gosh. So they know better, and they're not doing the right. They could have done the right thing, and instead they do this wrong thing, and they go, this is just an accident waiting to happen. It doesn't really matter who it is that comes along, whether it's somebody who's, Mother Teresa or a meth addict or whatever. And so, I like starting with the, you talk about what the defendants know, but then you talk about, the kind of the key moment where they could have done the right thing. And you kind of have to figure out for your case, when is it in the timeline? Like, I don't think an opening has to be sequential necessarily. You can start at this timeline and say, so when this patient came in, and they could have known this, and they could have known that, and they could have known this. you talk about what they could have done. They could have run this test, or they could have, this new employee comes in, they could have done a background check, and and if they had done it, they would have found this and this and this. But instead, this is what they did. They chose to do. And then they're like, oh my God. And then you can, if you want to, then you can kind of go backwards in time. If there's some more story before that until, and when they're making this decision, you can even say it. When they're making this decision, what should they do? You can tell them. Now, had they bothered to check, they would have learned, and all this other stuff in the back, in the past, you can kind of freeze frame there and go back. They would have learned that this guy had a stroke and, 10 years before, he had an allergy to this or whatever it is. And then you can bring him back to the president and you go, and then yet they chose not to run those tests or look at his file or whatever. And they chose to do this. And so, and so you haven't even told them about what happened with the plaintiff necessarily yet. So I think I like that structure of giving them that kind of focusing on that time when they could have done the right thing, and then everything they knew, and they just didn't do it, and they chose not to do it. And obviously you always want to frame it around a choice that they made, and tell the story in a way that, and it helps when you say they know this, and they know this, and they know this, but they chose not to do it, because then it sounds so much more deliberate, and it's just like a car accident case. Like, sometimes jurors will be like, well, this is just an accident. It's just an honest mistake, and it's not intentional. And I always like to sometimes put some voir dire on there on like, I always like to ask jurors, is being careful a choice that we make? Or do you choose every morning to kind of be careful and, in your jobs or in your lives or when you're driving? And the jurors will go like, yeah. And so it's like, being careful is a choice. And so I think you tell your story in a way that like, this is all a choice. They could have done, if there's some things that they could have done better beforehand, they probably could have done it long before. It's not just usually like a split second, decision. So telling it in a way that it is a choice. And if they just failed to do something, that's a choice too. And it really helps to tell them like so that helps you focus on what the things you tell the jury, because what they didn't do. But you tell them like, they know that, this is important. They've known this for years. Every hospital knows this.
I think it was one of your articles in opening, you talked about the importance of showing the two different, like the importance of showing the two different outcomes. It's not enough just to show, hey, here was the screw up and here's the bad thing that happened. But to some degree, you have to show them, if they had just done the right thing, they made the right choice, the safe choice, then, we wouldn't be here, because then this wouldn't have happened. And then the person wouldn't have gotten injured. You know what I mean? Like,
right.
You have to contrast those two, because it's almost like if you go, then it's almost too inevitable, like, oh, a bad thing was going to happen no matter what. And that's just the way that the world goes. You have to show, no, this was so easily could have gone a different direction. And it was because of that choice. And I didn't get to try this case, but my partner and I were on the brink of trying a birth injury case like a year and a half ago. And there was kind of this critical moment in the laboring process. Then you could see it. You could see it on the fetal heart strips, where there were these, there was a significant change, and now it was clear that this baby was in distress, and they needed to accelerate the time to delivery. And the nurse was just very blasé about it. And so, as we've sort of educated, like, this is what they know. And then you're saying, and this is what happened. What I was planning to do was right then to pose to the jury. Now, given what we know, do you think that nurse da-da-da should do this or do this? And then like pause, and hopefully the jury comes to the correct conclusion. Well, she does this, and now makes the wrong decision. And kind of go in that route. And I don't know if that was too heavy-handed or something.
No, I think jurors
choose your own adventure.
Yeah, jurors hate it when you tell them. I mean, one thing in opening, the biggest mistake I see made is don't tell them the conclusions that they should be making, especially early on. Even if it's like 100% where they're going to be at the end of the day anyway, they will hate you for it. You'll lose credibility, and they kind of like won't listen to you, and they'll be like, this guy's telling me what to say. I mean, the best openings, you're carefully leading them to the right conclusion, but you're not putting words in their mouth. You're not telling them what to think. You're just showing them, and you're just like, hey, this is just all about the facts. Jurors want you to give them the facts at the beginning. I don't know, what is this about? You tell me the facts of this case. Don't tell me what to think. And so yeah, I mean, I like that technique, because you're not saying she should have. I don't like in openings should have.
Yeah, right.
I like you say she could have. could have is like, wait, it's the same thing too, but it's just like for jurors, they're just like, yeah, she could have, and she didn't, she chose not to.
Right.
And so I like that saying, well, what do you think she should have done? Well, this is what she did, as opposed to she should have done this. And then now you're telling jurors what to think, and they don't like that. But if you lead them to, and they feel like they're the ones coming to the conclusion themselves, they're going to be way more emotionally invested in the case and thinking that you're just the honest guy, just telling them what happened. Yeah.
Do you have some thoughts on, sticking with opening, how you recommend approaching the damages discussion? And let's just say it's the person was obviously significantly injured. So you do have you can talk about the before stuff, or you can talk about, just how horrible they're injured now and that kind of things. Like, how do you approach the first time you're really discussing that with a jury in opening?
So not the damages specifically, but the harms, you mean?
Yeah, the harm. Well, that's interesting. I'd like to hear. Yeah, how do you handle the damages, and then how does it, or the harms, and then how do you roll that into damages, or what are some good recommendations?
Right. I like to talk. I think it's really important. To talk about damages and the harms really at the end. I have seen I've seen lawyers talk about damages early, because I know there's some thought out there that, hey, if you want them focusing on the damages and the harms and everything, that's what you talk about most, and you talk about it first, and it just rubs jurors the wrong way. If it's a disputed liability case, the jurors are like, what are you doing? I've seen them say this, and I guarantee you, for all the jurors who say it, there's 10 times as many thinking it. Like, what are you doing? You haven't even proven your case yet. Like, why are you talking about damages? Like, you're just trying to, they're like, what, so I really, in voir dire and in opening and in closing, I really believe in talking about damages last, after you've talked about the liability, because they get it then. But one thing that I have really learned over the last 5 or 10 years is that liability and anger about liability is what drives big damages. I just did a webinar with my friend David DiRobertis the other day, and he was like saying, like, he was like, and I asked him that question: how much of your closing do you spend on liability versus the plaintiff's harms and damages? And he said, like, he was like, in his biggest verdict ever, like $464 million verdict against SunCal Edison, he was like, it was like 2 slides of their harms. It was like a minute tops. And that probably would blow a lot of lawyers' minds, because they're like, how do you get, damages, or talking about damages? But really, it's just the liability will drive it. In voir dire, I focus on liability. Like, if you show me a juror who's going to get really angry what the defendant did, I don't need to know a whole lot about how they feel in a vacuum about damages. And same way when you're opening, I think that you certainly talk about it, but you kind of minimize it. You talk about so much more about getting them upset at the defendant and their choices and everything. And when you talk about the plaintiff's harms, though, certainly, it depends, I guess, on what the harms are. But, talking about, I agree with talking about what they were like before. I think you tell them, you tell them this is what the person was like before. And then you talk about, the struggles that they have. I don't like telling jurors. I found that it rubs them the wrong way when you tell them they can't do this, they can't do that. I think you just talk about, and you just really have to give just like 1 or 2 just examples that tell you everything you need to know about things that are super hard. And you don't even do it in a way that sounds like you're trying to get sympathy. And you just talk about, like, now, this is a guy who used to, who once, 2 years before the surgery, this is a guy who, hiked, the Rocky Mountain, like, the Rocky Mountains in like 70, he covered like, 200 miles in 3 days, or whatever the number is. I don't know if that's possible, but, and then you go, now, for example, when you hear from him, you're going to hear that, he needs his mom to tie his boots, or whatever it is. Like, you just don't, and all jurors need to hear when I'm prepping, same thing when I'm prepping witnesses, is like, you don't have to tell them, oh, my generalities, like my life sucks and I have so much pain and I can't do stuff. Just give them 1 or 2 examples of you trying and struggling and how hard it is it's just heartbreaking. And that's all they have to hear.
Yeah.
Jurors totally get it. You don't even have to tell them like life is hard. You just tell them that story and they're like, his life is hard.
Yeah, they get it. Okay.
So that's all. I think you just need 1 or 2 anecdotes. But in terms of a number, I've talked about this with a lot of people. I'm a believer in not, even if you're at a venue where you're allowed to give numbers for non-economics, and I know you can't there, but I don't like giving a number in voir dire. Other than, so in California, when we could theoretically say whatever we want, I like to give them a range. I like to say we're going to be asking at this case for many millions of dollars, but I don't like to give a specific number. I don't think it's good even in opening. I think that's something that you save for your closing. I think you tell them this is it's an important case and it's going to take a lot. It's going to take a lot of money to hold this company fully, or this doctor or whatever, or this hospital fully accountable for the harm that they caused, and framing it as fully accountable, because that's something to get off on a little tangent. I found you talk about pain and suffering and millions of dollars for pain and suffering, and jurors are like, a lot of jurors, conservative jurors will be like, I don't know about that.
Yeah.
Well, about quality of life? Quality of life, when I use the word quality of life, they go, okay, I get that. Quality of life is important. That could be worth millions, even though it's the same thing as pain and suffering. But then when you say, you're going to have a number that holds this company, this doctor or this hospital, whatever, fully accountable for the harm its choices caused. And as long as you say for the harm it caused this person, now it's not a punitive thing, you're allowed to say that. All of these jurors who are otherwise conservative, who would maybe push back and go, oh, millions to hold a company fully accountable. Yes, I'm totally on board with that. I mean, I did a focus group a couple of years ago in a wrongful death case where we asked this. There was this one pretty conservative juror, and I asked her in the focus group, I was like, how much money do you think that this widow should get in a wrongful death case for the loss of her husband? And she's like, she shouldn't get anything more than what he would have made in his lifetime, whatever that is. And then I said, well, how much money do you think you should give to hold this facility fully accountable for the harm that it caused this woman? He went, oh, fully accountable? Probably $1 billion. So, it's like just how you frame it.
Yeah,
so using fully accountable, that's a really important thing. But I know, we were talking about this earlier, like when you can't give a number, so you can't give a number in non-economics where you practice, right? For at any point, right?
Yeah, let's get into this. So no, not to get too much in the weeds. I mean, there's cases where you can make references to high value, objects or salaries and, so forth. And then there's, like the concept of anchoring and tug numbers and things start to come into mind. Okay. And I have some, good anecdotal evidence in the past of some interesting ways anchoring has worked, but still, I think many of us struggle that you can't tell. Although I will also say, and maybe you feel this way too, sometimes it can probably be a curse of suggesting the number. The only reason I feel more strongly than ever that the inability to suggest the number, it hampers our efforts here in Pennsylvania is what I have learned from the big data studies where, specific numbers can actually impact the liability outcome, whether it's the jury believing that, wow, by this number, they really believe in the case, by this lower number, maybe, I thought they would have thought it was worth a lot more. And obviously you get past the tipping point. It's like, oh, well, that's out of control. They're just being greedy. And now that turns me off kind of thing. That stuff's sort of interesting to me. But anyway, not to go off on a whole diatribe, but no, we can talk about the raw numbers of economics. We can talk about the numbers in our life care plans, but we cannot, suggest specifically a number for the non-economic losses.
Right. And so, and I dealt with this a lot when, I used to, I don't know how long ago, but 15 years ago or maybe more. I did a lot of work on some civil cases in Scranton and Wilkes-Barre with some friends out there. And I remember dealing with that issue of like, wow, you can't. Okay. And so what I do in those, when I recommend in those cases in voir dire and in closing, and it's the same thing that I do out here in California. There are some judges who in California who will in voir dire in mini openings, you can't say, no numbers. You're not allowed to say any number. I had one judge recently say, and it applies to both sides, because our argument is always like, well, the defense can get up there and say zero. Can you award zero? And like, so I can't say $10 million, but they can say zero. That's a number,
right?
And this judge said they can say that because it's like, can you give a defense verdict where they wouldn't get anything? But the defense can't say, would you be open to 30,000 if that's what the evidence showed you? So, okay. But anyway, so it happens out here too, that some judges say, nope, you can't mention numbers, at least in jury selection. But what I do in those cases, and so the same thing I would say for you guys in your closings, and this is what I did years ago, is say, I think what you can say, right, is you can say, this is we're asking you for a number for someone's quality of life. And, and we're going to be asking you to agree that a person's quality of life isn't cheap, that it's the most valuable thing a person, no matter how wealthy they can ever own. Even if you're Jeff Bezos, there's nothing more valuable than his quality of life. What wouldn't, he trade, any person trade for their quality of life, more than any. And so I like to say, in voir dire and in closing and opening, it's like, are you open to the possibility that it could be worth more than someone's lifetime of paychecks or any asset they could ever own? Are you open to that idea? Because some people feel like if you're not going to earn a certain amount of money in your lifetime, your quality of life shouldn't be worth that. You shouldn't be able to get that if your quality of life is hurt in an injury.
Yeah.
And so I think communicating that more than a lifetime of paychecks, more than most valuable thing someone could ever own, then I think these days everyone knows you're talking about millions of dollars and many millions of dollars without saying it. But that's the kind of way that I do it. And then you talk about, sometimes I'll say things like, it's got to be a number that, holds this company fully accountable for the harm that they caused. And so, sometimes in voir dire, I would even say things like, if we're asking for really big numbers, and without saying the number, if we're asking for really big numbers, are you going to be thinking, well, that's more than this person would ever even dream? Is that important? Or are you, and sometimes people say that and I'll go, do you think these big numbers, do you think that's a big number to these companies? And then they go, oh, I guess not, In a punitive case, you could certainly, I think, say, are you comfortable with deciding a number that's based on how big these numbers are for a company? But I think even without punitives, I think you can sort of talk about this idea that, like, are you open to the possibility that a person's quality of life and the harm that a company could cause is going to be a number that's, that's going to be big even for a company. So that's the way that I like to kind of handle it. That's the best way I've been seeing. Any pushback you think you get from the judges out there on doing that?
No.
Okay.
I don't. I think that absolutely would work. But sort of on a related note, because this concept of referencing, a lifetime of paychecks or something, the most valuable thing to them, and there's, I'm sure, debate on whether this is permissible or not. But there has been discussion, and there's been attorneys from PA that have been on this podcast in the past who've talked about, while not providing the numbers, talking about giving the jury a way to think about how to calculate the numbers, okay? How to calculate pain and suffering, because that's what I think they struggle with, is they don't have
like
some
a formula
type of thing. Right. And
right.
So I think even by talking about lifetime of paychecks, they can start to potentially think about, okay, that could potentially be a possibility. But I mean, and I guess where I'm going is, do you have a thought on how effective or not, per diem type arguments can be made, where you're giving them, like, well, you could consider, what would be in, the hourly rate for this person's pain and suffering, and you can assign that, but then you can imagine, because you're going to hear the number of what their life expectancy is, and you can imagine, okay, well, if we calculate that out, that they're going to be experiencing this pain and disfigurement for that period of time, then it's up to you as human beings, thinking about his life, everybody's lives, and the circumstances of the world these days, of what would be a fair hourly or daily rate from that. And you can use that to help guide, what might be a reasonable amount. I don't know if you think that those are effective or not, or.
Yeah, I use that a lot. I use and obviously out here we get to use numbers, but I think it's no different. I mean, you're not super hampered by not being able to use numbers, because they can imagine what number is.
Sure.
And I would just compare it to, I would compare it to jobs. I mean, I would even say, in some cases I've had the lawyers say in their closings, like, compared to like a CEO's compensation, CEOs have super stressful jobs. They got to pay them, a couple $1 million a year. Is this, you get to decide, is what this plaintiff is going through worse than the stress that this company's CEO, goes through?
Right.
That's up to you to decide. And then sometimes they're like, I've had a couple of juries say, like, give the number that their CEO is making or whatever, or what they think the CEO is making. Just because, like, they get it. I mean, if you have a good jury, they'll get that. And they like those formulas, it doesn't necessarily have to be a per diem. It could be, sometimes it's like an annual thing. I mean, like, what kind of job would you, what would you, if this was a job, I'm sure you've heard this before, but I do like it. Like, if this was a job that you had to sign up for, a person had this, my client had to sign up for, how much would they have to offer in this job to take it?
For anybody to take it, let alone my client.
Yeah.
Right.
And, and the other thing too, is that and that whatever the pay is, that's usually for 40 hours a week. This is something, this kind of pain, this is something they can't clock out of ever. They don't get vacations. They don't get weekends. They don't get time off. You got to pay, exactly. And so, what kind of, how much would it take for them to be, one thing that I've heard Nick, say a couple of times in the last couple of trials, which I really like, is he's told, when jurors have asked questions about damages, he's like, the damages should be a number where you give them enough, where you say, you can't complain anymore. This is enough where you and that's true. It's like, and the juror's like, okay, so whatever it is, so it's like, you give some lifetime of pain, you give someone $100,000. Is that gonna, do they have a right to keep complaining? In my opinion, of course.
All I got was this lousy T-shirt. Yeah.
It's got to be so much that you got this much money.
Yeah.
I don't want to hear you complain anymore. You can't use you're in a wheelchair the rest of your life, but we gave you, $80 million. You shouldn't complain.
That's great.
Which is it's a high amount of money to not be able to complain about these things, but that's just one way to look at it. But yeah, I kind of like the hourly, not the hourly. I like the kind of like the annual. I'm thinking about jobs, CEOs, and jobs that involve, high paying jobs, and comparing it to is that worse? Are they going through anything worse doing those jobs than
this new job that they've been left with that they never wanted in the first place?
Yeah, exactly.
Yeah. This may be a little anticlimactic to end on, but you're here, and so I'm going to try to get you for all the information I can get out of you. Yeah. So we touched on this earlier, and I want to give. So Keith Bruno, a long time ago, he did, and I think it was for Nick's trial by human trial service that they were doing. He did a video on his approach to the mini openings that I always thought was really great. Although I watched it so long ago, I've probably forgotten about it. But in Allegheny County, a lot of the counties around here, we get the opportunity to do these mini openings, and we typically, like I said, we have to kind of read them verbatim. But they get agreed upon, and generally speaking, both sides are kind of going to get to, they're kind of going to get to say what they want to say within reason. So with that in mind, when we're the plaintiff lawyers getting in there, I think there's always that, you don't want to over advocate, but you also want to talk about the warts of your case, but you don't want to turn the jury off and prime them that your case sucks too bad, Right. So what's the balance on how you approach, those pre-trial statements to the jury?
Right. So, we do mini openings in California. Every case you're allowed to, if even one side asks for it, the judge has to give it to you. And I think they're a super important tool. I think the thing that has gotten some lawyers stuck and confused about what to do is just calling in the mini openings. It's good that you guys don't call them that because it's a jury selection tool. It's not an opening. And when a lot of lawyers hear opening in anything, they think, I got to persuade people. And the dumbest thing you can do, the one thing I would beg you never to do, and every time I get in a case, I'm like, do not give the jurors even one good specific fact in your case. If you have 50 good facts in your case and you even say one of them, you're going to lose your good jurors for cause, because they're going to have something to judge the defendant by, and you don't want to give them a single thing. And so I'm going to read you an example of a mini opening that I have for a case, just to kind of tell you what's important in it. But the really overarching, the idea is this: at the end of your mini opening, you want the really bad jurors in your case to say, I've heard enough, because I do want you to tell them all the really bad facts about your case. Your guy was, your plaintiff had 2 beers before when he was driving that night, or your guy didn't read the didn't get a second opinion if it's a med mal case, and they signed something and didn't understand that, didn't ask a question or whatever. So you want to get those bad, but the point is, at the end of your mini opening, all the bad jurors are like, I've already heard enough. I don't care what else you have to say. This case sucks. I heard your guy was drinking. Oh my God, it's his own fault. I heard that this guy stepped into a huge pothole that was totally visible, and this case, it's his fault. I've already decided that. You want all your good jurors to have no idea whether you have a good case or a strong case, but they're just curious about it. And so I'll show you how I do it so that you kind of pique their interest and get them and make these sort of vague promises of what they're going to see. So basically, you could write it, put in all your good facts, and then before you do it, pull it out. And then instead of telling the jurors, for example, like some bad fact, some good fact for you, sorry, in your case, like, instead of telling them that this hospital hired a doctor who had literally never been trained on this surgery before, and it was like the first time, you tell them that you're going to lose people. Then instead you say, you're going to hear all the facts to judge whether this hospital was negligent or not. And you're going to hear what they knew about this doctor and what kind of training the doctor had and what, all that stuff. So you're sucking out the good facts and you're leaving them with like, you're going to hear about this and that and that. And so your good jurors are like, I have no idea if this guy Brendan's case is a good case or a piece of shit case, but I want to hear more. And so that's where you want it. If you give your good jurors, because there's so many good jurors out there these days that are ready to jump on anything. If you give them anything, you're going to lose them. So that's what I do. So I'll give you, I'll kind of take you real quickly through kind of the important structure. I write these for the attorneys I'm working with all the time. And I always say, good morning, everyone. This is an important case. And even though I'm sure you're not thrilled to be here on jury duty, we're so thankful that you are, because those of you who are willing to serve as jurors will get to make important decisions. And this is a really important line in here. Important decisions about the safety of public property and how careful property owners should have to keep their property for customers. That one line is really important. It's like your mission statement that tells the jurors, this is not just about this one plaintiff. Like, this is an important, I'm giving you what, and it may be, you get to make important decisions about how careful doctors have to be, or important decisions about how, careful hospitals have to be about staffing, how well they staff or whatever it is. And so the jurors are like, okay, this is an important topic, and I get to make important decisions about that. That's a really important thing to do. And you tell them, hey, the reason we're here is that in March of 2021, this is a case that I have coming up, a resident of an apartment building in downtown LA slipped and badly fractured his leg walking up a ramp to the front door of his apartment building. And the jury get to hear all the facts about why he fell and what actions the property owner took that might or might not have caused this and whose fault it was. And you say, my name is, blah, 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 and I'm honored to represent him. And I like to tell him, as much as I wish we could start the trial right now and tell you all the reasons why this property owner was a fault, I have to wait. That's what the trial is for. That line gets you out of telling them the good facts. And they're like, okay, I get why he's not telling me the good facts.
Yeah.
Soon enough, you'll get to hear everything to judge for yourselves if this was just an accident, or it was the plaintiff's fault, or it was the result of, the property owner making careless decisions. But I do want to share with you some of the issues in the case, so you can decide whether or not you'll have a easy or difficult time being, neutral or open-minded or whatever. And then you tell them the bad facts, and you go, like in this case, first, there was no video camera that caught it. You'll have to hear what happened. And second, this guy lived in the building. He had walked up this ramp many, many more times before. But I always like to balance it out by saying something like, but we'll also show you why this was the first time that this ramp was in the condition it was on that day. So you don't tell them specifically what, because in this case, it was like they were power washing the crap out of it. They're not allowed to do that. You have to have a permit to do it during these hours. It was like, they knew it was super slippery. So you don't tell them those things, but you just say, you'll hear why that's not relevant. Our guy was drunk, but you're going to get to hear why, that test may or may not be reliable or whatever. And then there's a damages part at the end, and if the facts convince you that this, company was irresponsible, you get to make incredibly important decisions about the value of someone's quality of life and how much money it's going to take to hold this property owner, fully accountable for the harm that their choices caused and everything. And I always like to tell them, because I want you to feel comfortable being upfront with me. We're going to be asking for a lot of money in this case, something like that. Obviously, for you can't give specific dollar figures, but you would say,
I could say that.
Something we're going to be telling you that we're going to be asking the jury to agree that quality of life is not cheap, and it's the most important thing someone could ever, whatever it. So that's how I like to say it. So you're giving them all the bad facts, but on the other hand, you're taking all the good facts out and telling them, you're going to get to judge this for yourselves, and you're going to hear all about what this defendant knew and what they could have done and what they chose. So you're just giving these generalities. And so your jurors are totally hyper-focused on that. And if you have a good case, then when you give your opening, you just see because you've kind of undersold it. You see their eyes, like their jaws drop, and their eyes like go bulging out because they're like, oh my gosh, I can't believe this case. I kind of thought, and I hear jurors all the time tell us, after jury selection, I really wasn't sure about this case. And then when I heard it, I was like, oh my gosh, why didn't he tell me this? And like, well, we would have lost you if you. So that's where you want to be with your statement of the case. Anything in there that you think would be objectionable to?
No,
as long as the other side. Yeah.
No, that is so helpful, and I think so applicable to how we can do our voir dire statements here, where you're touching on the fact that you will address those issues without giving away your good facts, but mentioning specifically the problem facts. You know what I mean? And then essentially saving your good stuff, so you're not losing your good jurors. I mean, that's so critical. And what about, on a related note, in cases where you've got catastrophic damages, and I worry sometimes that I could never be fair hearing that this was a child that was terribly injured kind of thing, or, that's you know what I mean? Especially it seems like
yes.
in the children injury cases.
So what I would,
you have to underplay it, I suppose.
What I would do in a case like that, is usually I have the lawyers handle that in voir dire. There's a kind of prehebbing I do on sympathy, but in a venue where you're not allowed to ask your own voir dire questions, I would probably try to get that into the mini opening if you can, and I would just tell them kind of basically, in a nutshell, what I like to say is, it's a sympathetic case. It's a child who has a brain injury or whatever it is. It's a kid. And I know people have strong feelings, and I always tell them, you're allowed to feel sympathy. Everyone's going to feel sympathy. And you're just not allowed to base your decision, on sympathy. And the example I like to give them is like, giving it, well, this is now a number, but, giving a crying kid who's lost ice cream cone is dropped on and they're crying and the kid's adorable, and giving them tons of money for that would be purely sympathy. You can't do that. But, deciding that someone's quality of life, a child's quality of life is incredibly valuable and worth a ton of money. That's not sympathy, as long as that's what your judgment tells you. And so we just want to make sure everyone in this case, even if you feel all the sympathy in the world, is going to use your judgment and decide, not $1 too much or too little. And, and as long as you can do that, and that way people kind of who know they're sympathetic, kind of, okay, well, and then you can say, I know you're going to feel sympathy, but can you use your judgment? Is your decision going to be made on judgment? And feeling like a doctor should be held accountable for what they do, be careful with a kid, that's your judgment, right? That's not just your sympathy talking, right? And feeling like, and the value of a kid's quality of life, their whole life, feeling like that may be valuable. Is that your judgment or your sympathy telling you that? And you go, no, that's judgment, right? So kind of framing it that way, I think, helps.
Well, Harry Plotkin, you have said it all today. I have hours and hours of more questions that I'd like to pick your brain on, but you have a life to live and a job to perform. However, I want to talk about a couple of things. One, do you have a podcast either out or coming out?
Yeah, I should have mentioned that when you probably talked about my jury tip. And so one of the reasons I stopped doing that jury tip years ago was I was like, I'm going to write a book for trial guides. And then I had young kids, and and my trial practice was exploding, and I couldn't. But I do have a podcast coming up.
What's it called?
Where I'm going to be teaching jury select. It's going to be focused entirely on teaching jury selection with my partner Dan Kramer, who's an amazing trial attorney out here in California. I'll show you. Let's see if I can. If I could show this to you.
Oh, wow. You might be the first.
I'll show you a real graphic.
On
This, what's it telling me? Oh, here we go. Hopefully this will show. Can you see this over here? So it's called Pick and Justice.
Look at this.
Are you able to see this?
I can. I love it.
There you go. Yeah. So yeah, it's called Pick and Justice. With me and Dan, we are going to be, there's some episodes where it's just us teaching. There are a lot of episodes where we're going to have amazing trial lawyers from around the country coming on here. Hopefully you'll come on here one of these days. We're going to be doing, right now it's going to be 2 a month, but maybe we'll end up doing more. Law Pods produces it, and they do an incredible job just making it easy for Dan and I just to jump right on and, interview the, Nick Rowleys and the Gary Dordicks and the Arsh Hamapours of the world. And so,
so you guys are, so Picking Justice is, so there's episodes out there people can go and listen to already.
So it hasn't, we're launching it. We're filming a bunch of episodes this month. We're launching it in January. So it's coming out, I think it's like January 13th. I think we're going to launch the first 2 episodes. And then it's going to be, at least twice a month with new episodes. And so,
very cool.
Totally focused. Because our thinking in that is that, like, you get all these great books and from trial guides on all these top openings and closings and framing and everything. And there's really not a ton of stuff on jury selection. There's some, but there's just not enough. And so we're hoping to fill in that gap. And that's why we're focused entirely on jury selection. And we're going to be, no topic is too small. We may have episodes where we're just talking about just the words that you use to describe bias, or how to frame. We already filmed one on how to frame bias at the beginning of your voir dire and things like that. So how to get cause and everything. So looking forward to that, and looking forward to having you on one of these days.
I that's a new life goal. Is just write it down for 2025. Is get on Picking Justice podcast. So that's awesome, and obviously everybody knows just listening to you what a wealth of information you are, and you got to go listen to that when they come out in January. And do you have you talked about, you teased it. Do you have a book coming out with trial guides at some point? Or is it still in the...
Yeah, not at this time. I recently kind of thought, okay, I think, because there was a time after that where I was like, thank God I didn't, because I didn't want the defense bar I didn't want to put anything out there that they could be seeing. But recently I'm like, I think I could give a lot of information without really worrying about that too much. It's not like I teach anything underhanded. It's not like I teach anything that's super tricky. But so I've thought about it. I may, in the next 3 to 5 years, write something on jury selection for sure.
And then lastly, Harry, as I mentioned, I'm going to be bugging you to consult on a couple of my cases. But if people want to reach out and consult with you, and there's a variety of different aspects of trials that you and your wife Claire can consult on, what's the best way to people get a hold of you? Just go to the yournextjury.com, or should they call you, email you? What's best?
Yeah, email is always the best for me. I'm sure it's on the website, yournextjury.com, but my email is just harry@yournextjury.com. So happy to, if people want to get in touch, ask me questions, just shoot those emails right over.
Awesome. Well, thanks so much for doing this, man. I got a ton out of it. I'm sure everybody that listens will as well. Wish you luck with the podcast. I'm sure that'll go awesome. And thanks for doing this, man. Talk to you soon.
Of course. It's a pleasure. Thanks, Brendan.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.